Welcome and thank you all for joining our webinar today. We really appreciate you taking the time to join us and learn about special needs planning for your loved ones. My name is Myra Medina and I'm the estate planning coordinator for the Koppenbarger and Koppenbarger law firm. Your presenter today is Robert Galliano, and he is one of the 9 attorneys within our firm. Robert has a master's in taxation. He's a certified specialist in probate, estate planning, and trust law by the State Bar of California, and he is a VA accredited attorney. Robert has helped hundreds of families over the years, and Robert takes the very complex and makes it simple. I'd like to welcome Robert Galliano.
Thank you, Myra. Before I get started, I want to make 2 promises to you. Promise number 1, I promise not to talk too long. Promise number 2, I can assure you that you will walk away from this time with us with at least 2 new ideas or concepts that you have never heard of. Before I get into the core of the presentation, I want to talk to you about a little boy by the name of Ben. Ben was a 9-year-old special needs boy. He was left at home by his parents with a sitter, qualified sitter, while the parents went to the market. As the day went on, evening started, the sitter started to get a little bit concerned because the parents were not coming home. Next thing that happened is that there was a policeman knocking on the door and talking to the sitter and trying to figure out if there was anybody there in charge of Ben. The police were not able to find anybody or any legal documents in place that would give anybody the authority to take care of Ben, and therefore they had to call in the Child Protective Services. And the immediate family for Ben, they were grandparents in Pittsburgh. So Ben's life was totally turned upside down. And what I want to share with you are steps that you should consider, so that a child like Ben in your life does not have to go through the trauma that happened in his life. We're going to be covering the following. 3 simple questions that I'm going to ask you. I'm going to ask what your concerns are, what you have considered for your short and long-term plans. I'm going to discuss how your special needs child will receive their inheritance. And I will also cover then the special needs planning, 10 steps that I think are very important for you to pay attention to and follow, because I'm sure that some of these steps you may not have considered. And then I will discuss the types of special needs trusts that exist. And then the most important thing is how we at Koppenbarger can help you. Now, the 3 questions, I want you to really ask yourself, what would happen to you if you did not come home like Ben's parents? What would happen? What would happen to the other children in your family if you did not come home? If something happened to you, something dramatic happened? What would happen to your assets, those treasured belongings that you currently own, your home, your bank accounts, your investments? How would these assets, how would these belongings that you treasure get into the hands of someone that can take care of a child like Ben? These are critical questions that I think everybody with a special needs child needs to consider and ask themselves, and this is what we're going to be discussing today. If you suddenly were gone like Ben's parents, and like Ben's parents, they had no plan in place, 0. Again, the police came to the door. There was nobody there that was responsible, legal authority to take care of Ben. And like I told you, the parents, the grandparents for Ben were in Pittsburgh. And they had to call Child Protective Services. And at that point then becomes a drama, an unnecessary drama, trying to figure out who would have the legal requirements, for who would take care of them on a short-term basis, somebody that could come, for example, to the immediate need when something like this would happen? And then also the other is what would happen then if you don't have long-term plans? Now, what do I mean by long-term plans? Long-term plans are the plans where you would have identified a caretaker, a guardian, a servitor, somebody that has the same values that you have, maybe the same religious background, that understands how you want your child to be educated, brought up. And this is a long-term plan that is very important, because the people that you place as in charge of your child under the long-term plan are basically stepping into your shoes and raising your child. And if you do not have a long-term plan in place and something disastrous like what happened to Ben's parents happens to you, guess what? There is a plan, and you're not going to like it, because it's the court system that now gets involved in your life. It's the judge that will decide the future of your special needs child. This is something that we don't want ever to happen. A court telling you how to raise your child? No, thank you. So all of us have an estate. All of us want to leave our estate to our children, to our beneficiaries. And when we have a special needs child, the way you leave the property to that special needs child, the way you create the plan to leave your assets to the special needs child has more implications than if you were to leave it to, I'll say, a non-disabled individual. So most people think that if you do a will, that a will will be sufficient. Most people realize that having a will is better than not having a will, although some of you may not understand that if you don't have a will, the state of California has prepared one for you. And now if you don't have a will and you are under the state of California's will that they did for you, or your will, and that's what is controlling the property that you want to leave to your beneficiaries or to your special needs child, guess what? You're going to end up in a court process called probate, or your estate may be subject to taxes, income tax, gift taxes, or it may be attacked by creditors with no protection. So in simple terms, people always want to know what a probate is. And I like to make it simple. Believe it or not, a probate procedure it's a lawsuit that you filed. You filed a probate process, a lawsuit against yourself with your own money for the benefit of the creditors, because the creditors then will have already a platform within the court system where they can come in and claim monies that is owed to them. Some of the money that's owed may be valid, some of it may not be valid. So I want you to understand that having a will to transfer property is not enough. That is not the ultimate way to transfer the property to your children, particularly to a child with special needs. Just to give you an example of the probate fees, one common misunderstanding. What is it? Well, look at the chart. I have there a home gross fair market value, $400,000. Typical cost of a home in Temecula right now, average cost. But let's assume that you have a mortgage against it of $300,000. So the value of the home is 400. You owe 300,000. So you tell yourself, well, my equity is only 100,000. Yes, that's true, but the probate court calculates the probate fees that are paid to the lawyer and to the executor, and they value the gross value. They do not subtract any liabilities. So in this example, you'll see the family home worth 400,000. In this example, the family had some bank accounts, stocks and bonds, 150,000, and they had a term life insurance policy for 450,000, but they had as the beneficiary their estate. This is a common mistake, by the way. So in this example, just to illustrate how fees are calculated, the estate total is $1 million. So a rule of thumb, keep it simple, rule of thumb, what are we going to do? Take 5% of the gross estate And that is roughly the general rule for all the fees paid to the lawyer, all the fees paid to the executor, and court costs. So in this example, transferring a house, life insurance, and some bank accounts is going to cost the family $50,000. Don't do that. And if you don't have a proper plan, if you have a child on special needs, what happens is that the child is receiving governmental benefits. And if the child is receiving governmental benefits, a lot of these benefits you have to qualify for. They are basically asset-based, income-based, qualifying type of accounts, type of benefits. And if you have an inheritance being left to a special needs child who is on benefits, the inheritance may kick them off of the governmental benefits, and you think you're leaving your child an inheritance to benefit them. Guess what? That network of benefits that they already have that they qualified for may be lost. So it is important that you realize that leaving an inheritance to a child with special needs requires special considerations. I'm going to cover now the 10 steps that I think you should follow, think about, in order to protect your special needs child. So let's go through them. Number one, all right, I covered this already, but you have to choose your short-term and long-term guardians. Short-term, those are the people that you have identified that in case of an emergency, they can come to your house and take care of Ben immediately. Long-term, these are the people that you might want to trust the care, upbringing of your child. It could be a grandparent, it could be another family member, but it's critical that you have named short-term guardians and named long-term guardians. They can be the same. They don't have to be different. But in the case of Ben, for example, where did Ben's close relatives live? Pittsburgh. So you think it's a good idea to have people in Pittsburgh be the short-term guardians? Not necessarily. Long-term, yes. Next, have you done what-if scenarios? Ben, for example, 9 years old in this example, his lifespan could be 70 years. So over the span of Ben's life, so many things can happen. You can't predict what life is going to hold for Ben. Will your child be self-sufficient? Will maybe medicines will help them to the point that maybe he is able to hold down a job? Have you considered the fact that maybe he could be self-sufficient? Maybe some children are already self-sufficient, but what if their illness becomes worse? You have to do what-if scenarios. What if grandparents die? What if they become ill? What if your child becomes worse with his illness? Do you have contingency plans? We all need it. With the COVID-19 right now, right? People get sick all the time. Some of them go to the hospital, they don't come out. So there's a contingency that we never thought of, right? So my point is that you have to sit down with your family and think about contingencies. Now, I don't recommend going into a conservatorship, but a conservatorship is a necessary process. When the child becomes 18, they're an adult. And here in California, guardians are for minors, conservatorships are for adults. You need to make sure that if the child becomes an adult, will he be able to make financial and personal decisions? Will he have grown to adulthood with the capability physically and mentally to be able to make the decisions? So a lot of times they cannot, and therefore at that point in time, you have to consider that a conservatorship. But there are some alternatives if you don't have to go down that route. And so let's talk about that. I'll talk about the alternatives to conservatorships in another slide, but right now what I want to cover, which is really critical, is the fact that when you have a special needs child, all parents and family members should get together and discuss and try to identify, try to study, try to investigate what are the governmental benefits that are available for the special needs child. Some of the public benefits, I'm not going to cover them all, and just for everybody to know that this one slide alone, could be the subject of a 2-hour presentation, because planning for governmental benefits is a highly specialized area of the law. But I want to cover some of what these things are. Primarily, I want to cover and identify a distinction which is confusing to a lot of people, and that is the term SSI and SSDI. Medicare, Medi-Cal, Medicaid, the alphabet soup, complicated. They all sound the same. They do different. What does it mean? Well, supplemental security income, SSI. There are two types of camps. There is the type of benefits that are what we call needs-based benefits, and there's another, I'll call it, area for governmental benefits. Those are entitlement benefits. Social Security income is a needs-based system. You have to qualify. There are specific requirements of assets and income and so forth. So you have to qualify them for the Social Security income. SSI, Social Security Disability Insurance, SSDI, that falls under the category of entitlement. What that means is that somebody who has worked and contributed to Social Security, you are entitled to collect Social Security disability insurance if you follow and meet the qualifications for that program, which is basically you're disabled, you cannot work, you cannot hold a job under the disability program that gives you the requirements as to what you can and cannot do and so forth. And Social Security disability insurance then is not a needs-based program, it is a entitlement benefit. Now, Medicare. Medicare is an entitlement benefit. How do you get Medicare? Medicare is when you reach the age of 65, right? When you reach the age of 65, we get Medicare benefits. There's Medicare Part A for hospitalization, Medicare Part B for doctor visits, appointments, Medicare Part D for prescriptions. Medicare is an entitlement program. So Medicare and SSI are entitlement programs. And if your child, for example, is receiving governmental benefits that are obtained by entitlement, you may not even need a special needs trust. That's the point I want to make. Social Security disability insurance, I think I said a difference. If you have SSI and Medicaid, which I have not talked about, there you were going to have to deal with special needs trust. If you have disability, Social Security disability insurance, SSDI and Medicare, that's when you may not possibly need to have special needs trust under those circumstances. We have to take into consideration that the kind of benefits that you have when you have how old you are, what assets you have, and then decide what is the best plan for you. And most often then the plan is a special needs trust. And I wanted to clarify to make sure that you understand there's two different types of benefits: the needs-based benefits and the entitlement benefits. Step number 5, we are talking about life planning. I'm not really talking about death planning. I'm talking about life planning. Life planning. you need to create a life plan for your child. Again, identify what public and private resources are available. You need to develop a financial plan. You need to create a life plan. Life plan is probably more important than the death plan. I'll talk about the death plan. But I want you to understand that you need to create a life plan, life care plan for your child. This is critical. So part of the life planning involves planning for yourself, you the parents. Why is that important? Well, Ben's parents died without any planning. We've been talking about planning for short-term, long-term guardians. We've been talking about the type of governmental benefits that you can have and so forth. But what about for you? What about you? What about your protection? What about keeping you alive? What if you become disabled? What if you are alive and able to make decisions? You make them. What if you're alive and you cannot make decisions? You're disabled. Now what? If you're disabled, who in the heck is going to make plans, life plans for Ben, for your special needs child? You also have to be sure that you protect the assets that you have, that you want to leave to Ben in a way that those assets are not taken away by court procedures, tax, and creditors. So you have to really plan for yourself first, and that is preparing a revocable living trust. And we're going to talk about this, and I'm going to talk about the other related legal documents, like the Advanced Healthcare Directive, Durable Power of Attorney, Pour Over Will, the documents that are part of your estate plan. Briefly, a trust. A lot of you have one. A lot of you have heard about them. It's just a legal document. It's created by you during your lifetime. It will transfer property at your death. Important as to how it's going to be transferred to a special needs child. I'll discuss that in a minute. But the important thing is that it will allow you then to control the distribution. It will allow you then to control where the money for the child would go. And you will see the next discussion that it has to go into a special needs child, a special needs trust for your kid. You will have control if you have a trust, and it will not go through probate. The Advanced Healthcare Directive on your left here, darker green, it's a legal document that you need to have for yourself so that somebody can make healthcare decisions for you. Remember, if you become disabled, somebody has to take care of you. You also need a durable power of attorney for finances. If you are disabled, you need to have somebody in charge. They're called agents, attorney in facts, to be able to make the financial decisions, sign your name. Again, this is a life plan primarily for you, in addition to the life plan that we have to make for the special needs child. Now, we have wills in addition to the living trust, because the job of the pour over will is to catch any asset, any property that was not placed in the trust during your lifetime and transfer it to the trust. But you have to be careful, because will is a will that will have to go through probate. These are the foundational documents that you have to have as a parent. And the distribution then is the following, in the sense that you have to have titling transferred over to the ownership of the trust, because the only way that the trust will control the property is the property that it owns. And therefore, we have to then retitle your property into the name of your trust, from yourself to the name of your trust. That's what we call fully funded. That's the only way for the property to avoid probate. You will control the money, how it will be used for your children. You will specify what would be left to your child's special needs trust. Here is the important point. You have to have a trust. You will then avoid probate. You can minimize taxation. You will identify within your trust what benefits go to Ben's special needs trust. Ben's special needs trust. Your trust then will distribute the property that you want for the care of your special needs child. It will go to his trust. So, what am I talking about when I say his trust? I'm talking about a trust that has been put in place by Congress that is aimed at holding money, funds for a child with disabilities so that the governmental benefits that they are receiving are supplanted by any money that you leave to the special needs trust for the care of the child. The money goes into the special needs trust for the benefit of the child. The child does not own it. You have a manager for that trust. And the purpose of the special needs trust is not to take over anything that the government would be paying, but is to supplant, augment, to make your child's life better. It will allow you to manage your child's resources while maintaining eligibility for governmental benefits, because the funds that are put into the special needs trust, when it's a well-drafted trust, they will not be counted as a resource, and therefore they will keep their governmental benefits. Remember the classification that I mentioned to you. There's needs-based entitlement programs, needs-based programs, needs-based benefits. You have to qualify for it. So we want to be able to keep these benefits, and therefore the ability to put money into a special needs trust will allow the child to keep the benefits. Now I'm going to briefly cover the different types of special needs trusts. This slide here, the surface that I'm covering here is just briefly to give you an idea as to the different types of special needs trusts that exist, because they're different. They have different purposes. They have different requirements. They have different laws. Two of them are controlled by federal law. The other one is mainly controlled by state law. If you do not know what type of special needs trust to create, that you go to someone who doesn't understand it, they may create the wrong kind of trust, and then benefits will be lost. So let's talk about it simply. The first one is called a third-party created special needs trust. What does that mean, third party? Well, it means that it's a trust created by someone, not the beneficiary, with money that goes into the special needs trust that is not the beneficiary's money. The money belongs to a third party, not the beneficiary's money. These are typically trusts that are created by parents, grandparents, and these are trusts that are created during your lifetime. Generally, these are created while you have a revocable trust. Remember, your revocable trust would then distribute upon your death funds to the special needs trust, which would then allow the special needs trust to augment the governmental benefits that he's receiving without losing the benefits that they have already qualified for. The main thing is that the third party created trust, because it's not created with the beneficiary's money, there's no requirement to pay the state back for any monies that the state has paid for the care of the child. Self-settled. Sometimes it's called first party special needs trust. This is the one that's created with the money of the beneficiary. Example, an insurance settlement from an accident, a large inheritance. But that's money that belongs to the child, money that belongs to the beneficiary. That's called a self-settled, meaning that you're creating the trust with the child's money. That one, whatever money is left at the death or termination of the trust, the state has to be paid back for any monies they have spent on the child's care. You see the main difference that I have on the chart here? Third party, no payback. First party, payback. I have reviewed trusts coming into my office, and I have seen the wrong type of trust used. And when I tell them that when the child dies, that any money left, you're going to have to pay back the state. They're floored. They don't understand how that could be. It is just understanding how these things work. Then there's another third type of trust, which is called the pooled special needs trust. These are the type of trust, just like the name implies. It's pooled. It pools benefits from different special needs children, and they're managed by an organization. And that type of trust, pooled trust, is used also, it's required to pay back to the state. But the most common trust that is created is the third party. You as the parent will create the special needs trust for the child. You will then fund it from the money that comes from your revocable trust to the special needs trust. And you will have identified then people that will manage the property when you're unable to do so. Now, during your life, you can also put money into the third party trust, or grandparents can put money into that trust. You will be able to manage the property. You will be able to manage the trust when you're alive. And you will also then identify successor managers to manage the trust when something happens to you. The purpose of the trust is simple. It's going to carry out your wishes. Mom and dad, you will be able to control what monies go in. You will be able to identify life insurance that is payable to the special needs trust. And you will know that having this type of system for your special needs trust child, you will know that they will still be under the governmental programs that they had. Protecting your child, carrying out your wishes, maintaining the program for your child. Important. Step number 8. You have to build a team. Short-term, long-term guardians. When they reach 18, you have to have a conservator. Who are they? Who would take care of them? Managers of your trust, trustees, successor trustees, agents under your health and financial powers of attorney, attorneys in fact, that's what they called also. Care advocates, family members who will understand how to care for the child. Your child is going to have to be the center of a team that you have to discuss with your family and identify what other assistance exists, so that when your child continues to go through life, like I told you earlier, Ben, if he would have had a plan in place, a lot of these issues would not have developed. Ben's estimated lifespan of 70 years, a lot of things can happen. So you have to have a team ready and in place to handle these contingencies. The documents that we prepare have to be flexible. The documents that we prepare have to be able to adapt to the changing scenarios that would occur in a special needs child's life. That's why you have to work with a firm that understands how these things work, because we're dealing with a revocable trust, we're dealing with special needs, we're dealing with taxation, we're dealing with governmental benefits, entitlement programs, Social Security income, disability. We have to understand how all of these things work together. And in addition to how that legal structure works, right, you have to provide a financial resource. It is your responsibility to make sure that there's enough money for Ben's life. Ben can live 70 years. Have you considered how you're gonna, what kind of money are you gonna leave for Ben to live to age 70? Have you considered what financial instruments you need to have? Have you considered life insurance? Generally, that is the easiest way and the best way to handle the amount of money that would be left for Ben to live until age 70. Have you considered the assets that you're leaving him as far as the amount of money that they can earn, inflation, taxes? At Cope & Barger, we have another arm of financial planners. They work with our firm, and they can help you develop a financial plan. They can help you identify life insurance requirements. They can help you design this plan, this financial plan. It's important to understand, number one is, who is going to provide the care for your children? How is the money going to be transferred over to your children so they don't lose the benefits? And how are you going to pay for their care? Number 10, do you want your child to remember you when you're gone? Have you thought of transferring your most intimate thoughts, your human, intellectual, and spiritual values? What is your most cherished memory? when you got married, when your child was born? How are they going to know how much you love them when you're no longer with them? How will your child remember you? These are things that you have to transfer in addition to the physical aspects of it, particularly for a special needs child. You need to give them a legacy of a transfer of these human, intellectual, and spiritual values. It's important. You have to try to leave a legacy. All good men and women must take responsibility to create legacies that will take the next generation to a level we can only imagine. All good men and women must take responsibility to create legacies. Have you created a legacy? Have you thought about it? Look, I'm going to give you two options. This is very complicated. You don't have to do this alone, you know. That's why we're here. You have two options. Option one, do it yourself. Yes, some people try to do it themselves. That's option one, do it yourself. Option two, work with an attorney that understands how this works. Work with a law firm that understands how special needs trusts interweave with the estate plans that are created, taxation issues, governmental benefits, entitlements. I prefer option two. Just like if I go to get my car repaired, do you think I can do it myself? Absolutely not. I choose option two. I will work with a mechanic. You will qualify to work with us if you own more than just personal belongings. Do you want a trusted advisor? Do you want to avoid probate, taxes, and take charge of the special needs child's future, not have the court involved? Are you willing to follow a system and structure? Do you want results? If you go to a typical law firm, with the advent of word processors, a lot of law firms will tell you that, look, we'll do a trust for you. You know what they do? They buy this program, they take information, dump your name and a lot of other data, and they spit out a document and they say, here's your trust. Not having the background or the degrees or the education or experience to really understand what's required. They do what we call transactions, all about form documents. Yeah, the typical trust, 99% of the time will avoid probate. But it may not be a system that's going to ensure that it's going to work when you need it. But when are you going to need it? You're going to need it when you die and transfer money to a special needs child trust. And if they have the wrong special needs child's trust, what's going to happen? You're not going to have ongoing legal advice from them. They're going to nickel and dime you to death. And you'll have no adequate protection for your child. How is our experience? You work with us. We build relationships. We build a relationship with you. We want to get to know you. You have to get to know us. We have attorneys in our firm that cover multiple generations. We will be there for you. We will help you get your financial house in order. We will help you to identify the financial plan for your special needs child. We will help you to protect your child in the documents that we produce. We can save you thousands of dollars. We've done it in the past. We've been in business for so many years. You will know that you made the right decision. You will know so for sure. We want you to have protection for your family's money from outsiders, creditors. We want to provide you with a lifetime of guidance and protection if that is what you see. Your plan's going to work when you work with us. Your family really needs it. Your special needs child needs it. You know what the biggest gift that you can do for your family? Give them a plan that will ensure that if something happens to you, they will be protected. That's the gift that your family will love the most. We polled a lot of you for questions that you may want to have asked, and so I will cover them briefly. And any questions that I may not be covering when you come in to see us, we will answer them. So just let me go through this list. The first question, if I start to the left here on the bottom left, going around clockwise, why are there different types of special needs trusts? Well, like I mentioned before, special needs trusts are designed for special needs, special requirements. A third party created by somebody else's money, the first party created by the beneficiary's money, and so forth, or the type of trust that needs to be managed by outsiders. So different types of trusts, they are implemented or designed to handle different situations. Next question, how do I prepare a financial plan? That is so simple. Call us, we'll get you together with our financial planning arm. They will sit down with you. Simply take basic information, how long you think you're going to live, what the assets are, inflation, taxation. That's a really straightforward answer. We can help you with that. Next question. Can the government take the money that I leave? Of course they can. If you don't properly design these documents, the government is there to take back what they paid. A lot of times the benefits that they give you is almost like a loan. So the answer is yes, they can, that it can be protected in a way that we can prevent them from taking it. The next question is a tough one. What happens when the money in the special needs trust runs out? That is a real problem, because when the money in the special needs trust runs out, then the child is left to the benefits that the government provides. That's why you have to make sure that you leave the inheritance for the child in a way that they do not lose their benefits. Because if this happens, you run out of money, the child will be dependent upon the benefits of the government. Next question. This is another good question. If I put money into the special needs trust, who gets the money? Child can't have it. The manager of the trust, trustee, gets the money. The money is not his. He has a fiduciary responsibility to manage the money for the benefit of your child. He's simply a caretaker with responsibilities, duties to act for the best interest of the child. So it goes into the trust. The trustee is the one who's in charge for the benefit of the beneficiary. Next question. This comes up often. What if I move out of state? The special needs trust will work in other states. Now, the qualification for some of the benefits, because some of the benefits are state specific, some of the benefits may not be identical than what they are in California, but their special needs trust, if properly drafted, will be able to move out of state with you. Final reminder, look, you hear it all the time. Update your plan. Establish a plan. We're experiencing a COVID-19 pandemic. Who would have thought that in 2020, we would be winding up in hospitals and dying more than before? You don't know what's going to happen. You have a special needs child. I need you to absolutely contact us. We want you to invite your family and friends to our next webinars. We have webinars every month. And the other thing that I would like to ask of you is, hey, if you enjoyed the experience that we had together, why don't you give us a review? Tell us what we did right, what we did wrong, and that will allow us then to do better the next time. I want to turn it over now to Myra. Myra?
Thank you so much for that, Robert. As some of you know, the Koppenbarger Law Firm, we've been in business for over 40 years. We have 8 full-time attorneys and 1 of counsel attorney, along with over 35 support staff members that are here to serve you for every need. We also have offices all over the state of California, 7 to be exact, And we can meet with you in person or through virtual means, such as this one. Our team will be sending you an email. In this email, you will have the recorded webinar so you can share this with your family and friends. It's very important that if you know anyone that does have a special needs child, please share this information with them. Many people have no idea that they need special planning for their loved ones. So if your adult children have a special needs child, a neighbor, a friend, let them know. Let them know that you've just encountered and you just were on a webinar that gave them vital information that they should hear, or give them our number and we'll be happy to call them and let them know what kind of planning they will need. As Robert mentioned, it's extremely important to have the proper special need planning in place so that the special needs child will be protected. Because you tuned in today, you are eligible for a complimentary consultation with one of our certified specialists. So whether you need to establish an estate plan for the first time, or you need to review your existing estate plan and discuss special needs requirements, we are here to help you, and your consultation will be completely free. So remember, we are here to help you through all of the stages of your life, and we appreciate being your expert referral for all your professional needs. We look forward to serving you and your family for the many years to come. Thanks so much for watching, and we'll see you soon. Take care.